Welcome to our viewers in the United States and around the world. I'm Mark Agrast, Executive Director of the American Society of International Law, speaking to you from Tiller House, the Society's headquarters in Washington, D.C. Today's webcast, the sixth in our series on international law and the Trump administration, will feature an expert discussion on increasing cybersecurity. The American Society is a nonprofit, nonpartisan organization with a worldwide membership, founded in 1906 and chartered by the U.S. Congress in 1950. Our mission is to foster the study of international law and to promote international relations on the basis of law and justice. These webcasts further that mission by providing the public with factual background and expert perspectives on the critical policy choices that will face America and the world over the coming months and years. Increasing reliance on computing systems has created vulnerabilities that can affect the security of financial transactions, the integrity of our election systems, and the control of critical infrastructure. Cyber attacks by governmental and non-governmental actors have taken place with increasing frequency, posing serious challenges to national and international security, and raising questions about the extent to which international legal norms apply in cyberspace. We're fortunate to have with us today two experts who served in senior positions in Republican and Democratic administrations, where they were responsible for formulating policy and advising the executive branch on cybersecurity issues. It is now my pleasure to pass the microphone to our moderator, himself a distinguished expert in the field, who will introduce our speakers. Michael Schmidt is the Charles H. Stockton Professor and Chairman of the Stockton Center at the United States Naval War College. He is also a professor of law at Exeter University in the United Kingdom. Professor Schmidt.
Well, I thought we would begin by placing the issue of cyber norms in contemporary context. Less than a month ago, the UN group of governmental experts that was working to identify norms of behavior in cyberspace broke down when the participants, which included 25 states, including the P5, could not agree on the applicability of certain basic legal concepts to cyber operations. Now, this was the fifth GGE that had been convened on the subject, and there was a lot of hope that this one was going to be extremely successful in building on the work of the previous GGEs, particularly that which was held in 2015. In 2015, that group of governmental experts on cyber issues confirmed that international law applied in cyberspace, including the UN Charter. It agreed that state sovereignty applied to the activities of states in cyberspace. There were somewhat veiled references to international humanitarian law principles, like the principle of distinction. There was mention that states should not look to proxies to commit internationally wrongful acts. And there was agreement among the states that had participated in the fifth or in the GG in 2015. There was agreement that states must respect and protect human rights and fundamental freedoms in cyberspace. So the question we're going to discuss today is, where are we with respect to the applicability and the role of international law in cyberspace? To do that, we have two people who I'm sure most of the viewers already know. Brian Egan, who is a partner with Steptoe and Johnson. He was, of course, in government. Most recently has the legal advisor at the Department of State. And then we have my friend Ashley Deeks from the University of Virginia. Before she was in academia, she was the assistant legal advisor at the State Department for political military affairs. So I thought what we do is we begin with the GGE, the collapse on June 23rd of the GGE, the failure centered on three issues, two of which had to do with the availability to states of certain responses to hostile cyber actions that were directed against either state infrastructure or governmental infrastructure. So Brian, let's begin with you. Curiously, in my mind, there was opposition to including reference to self-defense, the actual term self-defense, in the report that the GGE was to have issued, which is extraordinarily curious to me because previous GGEs had accepted the premise that the UN Charter applied in cyberspace, and of course Article 51 is the self-defense provision. So this begs the question, why would, at least reportedly, Russia, China, other countries like Cuba, why would they object to the inclusion of reference to self-defense in cyberspace?
Sure. Thanks, Mike. I think it's probably important to stress the context in which this question arose, which you did in your introductory remarks. So the UN group of governmental experts has convened for over a decade now in different forms. As you said, this is the 5th iteration of this group to address, among other things, the applicability of international law in cyberspace. And just to think about where the international community was at the beginning of this process, there was not even an agreement that international law applied in cyberspace. So within the last 5 years, as you suggested, we now have consensus, at least among this group, that in fact international law does apply in cyberspace, with a reference to the UN Charter. And the role of the most recent GGE was to kind of drill down on that a little bit more. What does that mean? Can we say anything more about that in a consensus group like the group of governmental experts? And I think so that's one piece of context. The other piece of context is this group was not a group of legal experts per se. This was a UN expert body, but made up of diplomats, of operational experts, legal experts, and others. And so this was not a purely legal exercise. I would say it's also a UN exercise. So there's always going to be a political and policy element to what a group like this talks about. So with that context in mind, I don't think that there's really a serious legal question that the UN Charter and Article 51 would apply in cyberspace. If one accepts the premise that international law applies in cyberspace, then it naturally follows that the UN Charter and Article 51 of the UN Charter, which talks about armed attacks and a state's right to self-defense in response to an armed attack, would apply. So I don't think that this is a legal debate per se. You could see a couple of reasons potentially why countries may not have wanted to advance the ball on this particular issue. One might be a political or policy concern that what would be said about Article 51 in this context could be misconstrued or stretched in other contexts. So if this group were to agree that Article 51 applied, perhaps others would try to say, well, that shows that everybody agrees that that there is cyber activity that amounts to an armed attack, which is what triggers Article 51. So that's one possibility, just a concern about misconstruction of what the group might come out with. Another thing just might be the things that we lawyers are more familiar with is just wording debates, where the negotiators just couldn't agree on the right formulation for something like this. And a third concern might be that given the amount of attention that has been given to cyber attacks, to the Russia's interference in the U.S. elections and other elections, that an acknowledgement by this group might be taken in a direction that some of the participants weren't ready to go. So, but I doubt that there was a true legal disagreement on the applicability of Article 51, which is part of the UN Charter, to state activities in cyberspace.
Well, so Ashley, in addition to the concern over the inclusion of reference to self-defense, there was also a proposal that the report would say states have a right to respond to unlawful activities in cyberspace. Although they did not use the term countermeasure, for international lawyers, we understood that to be countermeasures, the reference that states have a right to take countermeasures. Just for the audience, countermeasures are activities, could be cyber activities, that would be unlawful, but for the fact that they are in response to an unlawful act, perhaps an unlawful cyber activity, and they are designed to get the other side, if you will, to knock it off. So again, there was pushback on this as well as self-defense, which to some extent takes out of play all the responses of states to hostile cyber actions, except for retorsions, acts that are unfriendly but are lawful. What do you think explained the countermeasures? Is it sort of the same dynamic that Brian just explained with self-defense? I know you're an expert in state responsibility, so we'll let you opine.
Well, so I think Brian's point about if we accept that international law applies in cyber, as previous GGEs had, then what follows from that is that the rules of state responsibility and countermeasures would also apply. So I suspect that some of the same dynamics that drove the self-defense fight probably also drove the countermeasures discussion as well. I guess I can imagine two reasons that are more or less credible as to why states might have balked about a specific inclusion of countermeasures. One is the fact that, as you note, countermeasures only come into play when there's an international law violation. And in the subuse of force area, there's a lot of ambiguity about which cyber activities constitute violations of international law. So it could be that the fuzziness about what the international law violation would be gave states some pause about affirming the applicability of countermeasures. It doesn't make a whole lot of sense given the 2015 statement, but that could be sort of the ambiguity could be driving that. There might also be some embedded concern about tit-for-tat escalations that could occur even in the subuse of force area in one state feeling as though it had suffered an international wrong to it, responding in cyber as a countermeasure, having that state resist the application of countermeasures and try to countermeasure back, for example. And so some states might have been worried about setting up a possibility for escalation in cyber where things seem to pretty quickly be able to get out of control.
So the opposition, there were a number of states in opposition, but the reports are that Russia and China were in particular in opposition to both self-defense and to countermeasures. Could the opposition be that they're very active in terms of engaging in hostile cyber operations against the United States and other countries, and they don't want to lay on the table a legal option for other states to respond to their hostile cyber operations? In other words, is the opposition driven by the fact that they are engaged in activities that might well be characterized as internationally wrongful acts, unlawful acts? What do you think about that, Brian?
I think that's a possibility that probably extends to almost all of the GGE participants. Is I think one of the reasons why it's so difficult for states to talk about international law and its application in cyberspace is this is an area where many states operate in secret. They don't talk about what they do. Their operations are somewhat fuzzy. And so I think it's very possible that Russia and China were driven by those concerns that activities that are really speculated about in public sources but are followed very closely within governments could be seen to be unlawful pursuant to the rules that this group would develop. And then the measures that Ashley just referred to, like countermeasures, would then kick in.
Would open the door.
So, I mean, I do think that across the board, and including maybe what we'll talk about in IHL, there is a potential political resistance to this to just increase flexibility on the one hand of states that don't want to see in black and white that certain things should be off the table. There may also be an effort on the part of some states that resisted these norms to deprive other states, say the United States, of rallying support for its response by being able to point to a document like this and saying, look, we all agreed that there is a right of self-defense in response to a cyber-armed attack. So it potentially makes it a little bit more difficult for states that are trying to play by international law rules to get robust support and justification for their actions if not all states have agreed to.
Right. So the other thing that there was pushback in the GG had to do with reference to international humanitarian law, an express reference. If you will recall, and I mentioned it in the 2015 report, there was also their opposition to inclusion of the term international humanitarian law, but they included reference to a number of principles: distinction, proportionality, and necessity, and so forth. Now, this leaves, I'll put on my British professor hat for a moment, this leaves me absolutely gobsmacked, to use a British term. And the reason is the ICRC, virtually every serious international humanitarian law scholar, obviously the United States, NATO, all agree that international humanitarian law applies to cyber operations that are conducted during either an international or a non-international armed conflict. It's difficult to see how it would be otherwise. I had the opportunity to ask someone from one of the countries in opposition, someone who's participating, what in the world are you talking about? And His answer to my question was, well, we're very concerned that if we have a reference to international humanitarian law in a document that has to do with cyberspace, then that will justify the use of cyber operations during an armed conflict. I have to tell you that that left me scratching my head, trying to understand what in the world is this man talking about. What could possibly be the motivation behind opposition to an express statement that international humanitarian law that protects civilians and civilian objects, for example, medical facilities, does not apply during an armed conflict? Can you tease loose any possible explanation?
So I'm probably as gobsmacked as you are. I think the exclusion is definitely puzzling. And the idea that you are simply hoping that states won't use cyber in armed conflict at this point is really putting your head in the sand. I think the person you spoke to is putting the cart before the horse, or cart behind the horse there. It's certainly the case, and again, this might be true for self-defense as well, that some of the states around the table might not have the level of capacity that states like the United States and Russia and China do. So they don't really they can't put themselves in a position of imagining the use of cyber in armed conflict. But that's not a legal question, right? That's a technology and capabilities question. So it's possible that they're contemplating this idea that attacks, which is a phrase used throughout the laws of war, as relates to attacks on civilians and attacks on military objects. There might be some argument in the minds of these states that opposed it that cyber operations are not the kind of attack that the law of war envisions. Now, I think that's a problem. We have seen, for example, we would say chemical weapons attacks, which don't actually produce a kinetic result, are attacks. So I don't think that's a strong legal argument, but it is an argument people potentially might be making. But the idea that it is somehow appropriate to use cyber to conduct attacks against civilians or attacks that aren't directed against military operations, and that is fine, seems deeply misguided. And I imagine in this case, if you were to see a state using cyber without heed to the principles of distinction and proportionality, that state would be strongly condemned by the other actors in the international community.
It seems to be a misunderstanding about the nature of international humanitarian law. I mean, international humanitarian law is essentially protective in nature. I mean, you can make the arguments that at times it justifies actions, for example, the targeting of military personnel and belligerent immunity and so forth. But it just strikes me that to suggest that international humanitarian law justifies actions instead of protects individuals and objects is a curious approach to humanitarian law. Brian, you would agree? I see you nodding your head.
Yeah, I think that international humanitarian law clearly establishes rules of the road for armed conflict, as you said, Mike. And one possible explanation for this is that while there's consensus, essentially, that international humanitarian law applies in situations of armed conflict, of course, there's a great deal of disagreement within the international community, within individual governments, about some of the individual rules that are part of IHL. And it may be that the countries who are objecting to an inclusion of a reference to IHL in this context were concerned that by including IHL, they would be endorsing an approach to IHL that maybe they didn't agree with. But I tend to agree that this is likely another one of those areas where there's not really a legal disagreement as to whether IHL applies, but it's more of a policy or political concern with the implications of a UN group of government experts coming out with a statement like this.
It just strikes me as extraordinarily dangerous. I mean, the first consideration of international law with regard to cyber occurred many years ago at the Naval War College. I was then a student there, an Air Force officer attending War College, and the topic of the day was cyber operations, because we had just discovered cyber operations, and the operators, the military operators, were waxing eloquent in the seminars about all the things they could do with cyber operations. Listen, we can attack dams, and that the law department at the War College they caught on to this and said, holy cow, this could be very, very dangerous, and we need to begin to look at the international law applicability, and held a conference that really kicked off consideration of international law in cyberspace back in the 90s. So it strikes me this is a dangerous trend. Well, let's move off of the GGE and talk about some of the issues that are currently in the debate over the applicability of international law to cyberspace. And one that is a rather hot topic within and between governments is sovereignty. I think that this debate caught a lot of people by surprise. It's a new debate, but it goes like this, and I'd like your reflection, both of your reflections on this debate. There appear to be two camps. One camp says that there is a primary norm, a rule of international law that prohibits violations of sovereignty by cyber means. So you conduct a remote operation from state A into state B, and that may be a violation of state B's sovereignty. For those who are in this camp, I'm one of them, for those who are in this camp, the question is not whether sovereignty may be violated. The question is which cyber operations do violate sovereignty. Remote cyber operations do violate it. Is it limited to those operations that cause damage or destruction? Does it include the implanting of malware into another state's systems? Does it include manipulation of processes of cyber infrastructure, whether it's private or public? So the question for this group is not, is sovereignty a primary norm? Can you violate sovereignty? The issue is, when do you do so? That's Group A. Group B, the opposition, and I should mention that Ashley put this together. There is a forum, I guess, in the American Journal of International Law, Unbound, that is forthcoming in the very near future. Yep. That will present both sides of the debate. The other school of thought says, listen, sovereignty is not a primary norm. You don't violate sovereignty. Rather, it's a foundational norm of international law from which other prohibitions emanate, like the prohibition on intervention. And so a cyber operation by one state into another state does not violate that state's sovereignty ever. You have to look for a different violation of international law, a different internationally wrongful act. So this debate is a hot one. I was just on the phone to the UK yesterday about this debate. It's a hot one here in the United States and elsewhere, in the United Kingdom and elsewhere. I wonder if you could give me your views on this debate. Who's right? And are there any practical implications to this debate, or is it just academic? Ashley?
So based on what I've read about the, including in ICJ and other jurisprudence, the court definitely seems to refer to sovereignty as a standalone primary norm, apart from norms like use of force, non-intervention. So in my perspective, asking the question, what kinds of cyber activity would constitute a violation of sovereignty is the right question, and a hard question. So I will refer to Tallinn 2 here, which is, of course, a project with which Mike had deep involvement. So the Tallinn Manual takes this former approach, and so the question that Tallinn asks is, or would have a state ask when trying to assess a cyber operation, what's relevant is the degree of infringement on the target state's territorial integrity. And there it seems like often the question is, did the cyber operation produce damage, or physical damage, or serious sort of computer-based damage? Or has there been an interference with or a usurpation of an inherently governmental function inside the territorial state, the state whose sovereignty might be compromised? So we can think of a couple of examples there that I think many people would think pose sovereignty violations. So interfering in the process of conducting elections, the actual process of it. We'll maybe talk about that in a sec.
I can't imagine that would ever happen.
Fair enough,
But,
right? Hypothetically.
Just hypothetical.
Or, for example, interfering in the publication of legislation that's just been enacted, or falsifying Supreme Court opinions as they hit the web. Those all seem like, or shutting down government websites, interference with something a government has a unique claim to be able to conduct within its territory. So just to put a little nuance on the other side, right, I think what the concern would be from maybe the U.S. government or parts of the U.S. government might be, if you say that sovereignty is a primary norm that can be violated, there are a number of activities that states might wish to undertake against non-state actor systems inside another state that might, if you set the sovereignty bar too low, might be captured by that bar, even though that might not be the kind of thing we all really had in mind when we were forming the sovereignty norm in the first place.
Let me follow up just a little bit, and then we'll turn to Brian. So on the non-state actor, if you take the approach that sovereignty is a primary norm, does that really preclude operations against non-state actors? Because of course you could get the consent of the territorial state where the non-state actors are located. And in the event that that state did not grant consent and the non-state actors' activities seriously affected you, it would strike me that the principle of due diligence would apply such that the territorial state was in violation of its due diligence obligation, thereby opening the door to for you to engage in those very operations you want to engage in as countermeasures. So, I mean, I've heard this, but I'm unconvinced by the argument, because it would seem that the application of these principles would generally allow you to engage in the operations against the non-state actors.
Well, so that then takes us to the question about, is due diligence in cyberspace now an internationally recognized and accepted norm, right? Because as we talked about earlier, you would need a violation of international law in order to trigger your right of countermeasures.
Right.
So maybe we can talk a little bit about whether due diligence is widely accepted now in the cyber context as a norm and what it entails, right? Again, that gets complicated. But where I thought you were going was to say, look, you can imagine a response to a non-state actor via cyber means inside another state that wouldn't necessarily violate the norms of sovereignty as Tallinn has teed them up. Right. So even if you accept that it's either interference or usurpation with a government activity or infringement on the target state's territorial, it depends what the response to the non-state actor.
It depends on where that threshold lies.
May not implicate the territorial state's equities as sort of a governmental perspective. And if it doesn't produce the kinds of physical damage that we think might be necessary to constitute a sovereignty violation, well, then you haven't violated sovereignty. You haven't
violated sovereignty. Right. Absolutely right. Well, Brian, maybe we can follow up on the due diligence. So during the Tallinn Manual process, the Dutch government sponsored something called the Hague Process, in which a number of states, 50 states and international organizations like NATO, OAS came and commented on drafts of the Tallinn Manual. It was in a non-attribution environment, but there were a number of states that were nervous about this principle of due diligence, this principle that a state must put an end to ongoing cyber operations that seriously affect another state. They have to police their territory, if you will. There were a number of states that were concerned about that. You were then the legal advisor at state. I wonder what your thoughts are on this obligation.
So I'm going to wait till Ashley's Unbound volume comes out to answer any definitive questions on this topic.
Oh, we don't talk about due diligence in there.
It's probably smart. I think due diligence, in my view, and this is just my personal view, there's a little bit of a cart before horse issue when you talk about due diligence and cyber operations and cybersecurity, because I think for some states, there's a reluctance to commit to a particular position or a useful position on due diligence without having some agreement as to the rules of the road as to what appropriate behavior in cyberspace may amount to. Right. And so if you have tech companies that are engaged in activity that may be problematic from another state's perspective, but maybe not from your own perspective, is there international agreement that those activities are the type that would trigger the due diligence obligation? I think that you can look to a lot of other areas of international law for support for the principle that there is some requirement for a state to exercise due diligence in constraining the behavior of non-state actors on their territory that adversely impact other states. But the contours of when that's triggered and what you
Right.
must do, I think
Right.
are where you get into real concern.
It was interesting, the GG actually looked at the issue. In the Tallinn Manual, we had unanimity among the 19 experts from around the world that it was a principle that applied in cyberspace. But when the group of governmental experts looking at cyber norms considered the issue, the text says states should take action to instead of states must. So it wasn't a binding legal norm. Brian,
Can I
I'm
just
sorry,
add
yes,
one
of
more to that?
course.
So there's also, maybe this isn't a legal question, but more of a policy question. So I think there's some concern from more civil libertarian type groups that are worried that if you set the obligation too high, you're basically asking or authorizing states to spend a lot of time in their own networks,
Yeah.
patrolling and monitoring. And so there are people worried that that means the NSA will be in all of our private networks trying to make sure that nothing hostile emanates from our territory. And likewise, we might then be encouraging more authoritarian states that are already quite deep into their own networks to sort of bless that kind of
Right.
activity, when at the same time we have sort of a human rights perspective on that encourages freedom of expression on the internet and so on.
Yeah, absolutely. So that came up. The other thing that came up with due diligence in the discussion was, goodness gracious, you're imposing an incredible obligation on us. You know, we're a state through which lots of cyber operations pass, the United States and other states, not just the United States. And the obligation to put an end to hostile operations from our territory is an extraordinary obligation that would have extraordinary practical consequences. Now, the answer was, and it's an unsatisfactory one because it's not precise, well, you only have to do what's feasible. Well, you know, what's feasible. So Brian, let me turn back to you because Ashley mentioned the elephant in the room, elections. I wonder if you could talk a little bit about interference in elections, whether they're U.S. elections or elections abroad by states. You know, to what extent is this unlawful? What are the remedies that are available to interference? What's the legal standard? What are your views on this?
So just to take a very brief step back, when in these discussions that are ongoing in governments and academia and elsewhere on unlawful activity as a matter of international law in cyberspace, there are really three topic areas we've touched on briefly, but just to recap, one is sovereignty,
Right.
whether or not that in and of itself is a principle that can be violated. Two is what we'll talk about in a moment, non-intervention, the principle of non-intervention, which I think Ashley referred to a few minutes ago. And then three is the use of force, all of which raise separate questions. And I think when people talk about interference in elections, they really talk about this second category, the principle of non-intervention. It's a customary international law principle. In my view, there is a customary international law principle of non-intervention that can be violated by states. I think you look to things like the ICJ's decision in the Nicaragua case, where the ICJ recognized the principle. They basically say this stems from the right of states to conduct their own affairs without interference. And then I'm going to flub this a little bit, but they basically identify two elements to non-intervention. One is the intervention, the unlawful intervention must be on a topic which is really within the exclusive domain of the state itself. For example, the choice of a political system.
Right.
And then two is the unlawful intervention needs to involve some amount of coercive behavior on the part of the other state, with the use of military force being the classic coercive behavior, but not limited to the use of military force. So activities within the exclusive domain of the state where coercion is used by another state to try to influence those activities. When you talk about an election, a US election, a French election, a German election, I think there are some areas where I would say it's pretty clear that activity would violate the principle of non-intervention. So, for example, an attempt to actually go in and manipulate voter data by one country with respect to another country. You're changing the results of the election directly. That seems to be a very clear-cut example of a violation of the principle of non-intervention. On the other side, you have states that maybe express views about what they think the outcome of an election should be. They do so publicly. They do so with attribution. President Obama said he really hoped that the UK would not vote for Brexit.
Right.
You know, I don't think anybody would say that that would violate the principle of non-intervention. So really, this area in between those two extremes is where the debate takes place, and where you talk about things like false news stories that are designed to impact particular precincts in a voting district. I think that the question gets much harder, and you may have areas where a state is sophisticated enough to really cross that line, where they know that if they take an action, it could lead to a change in election results. But I don't think it's very easy to define exactly where that line would be crossed.
Mm-hmm. So, I mean, you're right. The co-editor of the Tallinn Manual and I have a long-standing debate. The Russian activities with regard to the DNC strike me as coercive in nature because they manipulated the process of the elections. And she's the CEO of a company, Cyberlaw International, and she argues, no, that's not the case. That's not coercive enough. Ashley, Brian has said it's difficult. Did the Russians violate international law with regard to the DNC hacks?
So I'm inclined to think, A, it's unclear, but B, probably not.
Probably not,
probably
because...
Because they didn't falsify the information. I feel like that's an important...
But didn't they
measure.
manipulate our process? It's quite one thing to have, to support Brexit. It's quite another to engage in an activity that is unlawful under domestic law, and then use that to manipulate opinions in another state. That isn't coercive?
Well, what they did, as I understand it, is they collected emails, they hacked into
Right.
emails, and then released them
Right.
without change. So
Right.
they were introducing information into the government system, the system of
Right.
debate,
Right.
for democracy to effectively evaluate. Now, I'm not blessing what they did. I
Right,
don't
right,
think it was
right.
a good thing.
Right.
But if the question is, does that violate international law? I think that's a really hard question. I think I would be more inclined to say yes if they had actually altered the emails.
Yeah, absolutely.
That's much more coercive and
It-
more interfering in the actual process.
It's a that was a very interesting incident because of this debate we're having. I mean, it really does seem like certain states are identifying areas of the law that we've talked about that are unsettled: sovereignty, the coercive element of intervention, even where does the use of force line lie, et cetera, et cetera. It seems like certain states are actively operating in cyberspace in those areas which have been called gray zones of international law. Do you believe that this is just fortuitous, or are states actually leveraging the uncertainty of international law in an effort to advance their own agenda? Is that?
So it wouldn't surprise me because it is harder for the victim state to affirmatively
Right.
stand up and say, that's a clear international law violation, and
mhm.
here's what follows from it. There's a little bit of a difficulty in some ways in what the US and the UK and EU are doing. I think on the one hand, it's great that they are trying to articulate
Right.
cyber norms, including the ones we talked about earlier today. But they are basically saying we are going to comply with the laws of war when we
Mhm.
engage in cyber. We do think that there is that countermeasures could be used, but presumably subject to the procedural mechanisms and so on. So in some ways, we are tying our hands by saying, here are the rules we're going to follow, without being sure that the other states are going to do that. And that may well be the right thing to do,
Mhm.
but it
Mhm.
does make it a little bit more difficult for us in our sort of larger geopolitical operations.
Brian, you agree?
I do. I think that there is a certain amount of self-reflection that has to take place in developing and articulating what we believe, any country believes to be the rules of the road. I think it's been interesting, though, to watch the international response to what Russia has done in US elections, in Ukrainian elections, in you name the elections. There has been, so far as I can tell, universal condemnation of the methods that Russia has used, particularly the hacking methods, but then also at least the alleged use of falsified news stories through social media and other ways to spread rumors about particular candidates or parties. And I kind of wonder whether we're seeing the customary international law develop in the more kind of organic sense, where you have enough states making statements about violation of international legal norms and customs, as the United States has done. You're going to have the next Tallinn Manual team who's looking for state practice. Well, you're not going to find states putting out their treatise on cyber, but you'll see some pretty good examples of states condemning other states' behavior in this space.
Right. So you have opinio juris.
Yes,
state
the
practice
development.
opinio juris and well, let me change just a little bit. Every time I go out and talk about cyber, and I'm sure the same is true for you, there's someone in the audience that asks the attribution question every single time. How can you have international law? International law is going to be meaningless because it's absolutely impossible to attribute in cyberspace. Of course, there's the issue of technical attribution. Can you attribute? Can you actually factually say they did it? And then there's the issue that's often missed in the dialogue, and that's the issue of legal attribution under the law of state responsibility. When is a state responsible for the activities of a non-state actor like a hacker group and so forth? I wonder to what extent, and we'll start with Ashley, I wonder to what extent the issue of attribution, whether it's technical attribution or legal attribution, to what extent is it an obstacle to really putting teeth into international law in cyberspace?
So I'm not sure I'm cleared for that answer. I think I only know what I read in terms of states' capabilities with regard to attribution. And it seems from news reports as though states are getting more sophisticated and better at being able to attribute activities, whether to a non-state actor or to a state, or potentially to a non-state actor that has been hired by a state. And attribution is obviously really important as a factual matter, because if you are hoping to respond, you need to know who you're responding to, whether it's in self-defense or as a countermeasure. And if you get it wrong, your response against someone other than the aggravator could be an international law violation in and of itself. So my sense is that attribution is improving. As you know, the U.S. was willing to come out and attribute the North Korea Sony attacks. But of course, there's also again, not a legal problem maybe, but a sort of political problem of worrying about revealing your sources and methods when you do attribute. So there's increasingly an expectation, I think, in the world at large that if you're going to attribute an attack, you might need to say something about why you think it was that state, but then you're potentially compromising some of the sources and methods that your intelligence community or military might have used to be able to attribute it internally.
And Brian, you were at the helm when the United States was the target of a number of noteworthy hostile cyber operations. How did you deal with the issue of attribution?
I agree with everything Ashley just said. I think attribution is, and you mentioned this too, Mike, it's clearly an operational issue. There's, can a state actually come up with the evidence it would need to accurately identify the perpetrator of an attack? There's an intelligence sources and methods issue. Is a state willing to reveal those things? I'm not sure there's really a legal issue, though, that's any different in cyberspace than there is in any other case where state A wants to accuse state B of some sort of an international law violation. A treaty violation often raises issues where state B is going to say, no, we didn't violate the treaty. Well, as state A, you've got some requirement to, within reason, make sure you know what you're talking about when you accuse state B of violating the treaty. And if you take countermeasures that we talked about a little while ago in response to the violation and you're wrong, your countermeasures were themselves unlawful. So I think that this is a concept that we kind of know how to deal with as international lawyers, even if it raises different operational and intelligence issues in the cyber area than it does maybe in other areas.
What about during the Hague process, a few states made the argument that if you're going to attribute a hostile cyber operation to another state, you got to put your evidence on the table. It's what you were talking about, that there is a legal requirement to put your evidence on the table. of course, a number of states immediately fell to the ground frothing at the mouth at the notion that this would be a legal requirement. I wonder to what extent you believe that it's a legal requirement, or at least a requirement of best practice in international law. Maybe Brian?
I don't know if I would be one of the frothing on the mouth types, but
Okay.
I'd be probably in their camp, that it just can't be the case that a state has a legal requirement to put all of its cards on the table in accusing another state of some unlawful behavior. Because I think there's probably a norm that we would want states to put certain information on the table, and we would want states to probably be public when they're accusing another state of violating international law. But the idea that it follows as a legal matter that a state would then be required to reveal all of the information that forms the basis of their conclusion, I don't see the source for that or the state practice.
Well, a number of states take the opposing view, as you know, and they seem to be states that are engaged in rather malicious operations in cyberspace, so they don't want to be condemned, and so obviously they say, where's the beef? Let's change the focus a little bit to the way ahead. It strikes me that a number of multilateral efforts have been hobbled by political concerns. Can't come to an agreement, the GGE most recently being the best example of this. So, Brian, you were in the business of advising policymakers on the way ahead. What's the way ahead? Should we continue another group of governmental experts to try again? Should we try softer approaches? Should we try more bilateral approaches, working with Five Eyes countries, for example, or other close? What may work to advance the dialogue? Because if there is a theme that's come out in this chat so far, it's that lots and lots of the law is unsettled. So how do we get some forward motion on this?
I think there's clearly a desire for additional clarity between states, including some of the states who are sometimes adversaries, or we think are adversaries in cyber actions, for rules of the road in certain areas of cyber activity. And to me, it's been interesting to see how that has played out in terms of some other bilateral and multilateral fora where cyber issues are discussed. So take the GGE to start. One of the more interesting parts of the GGE process to me was not so much the legal rules that were articulated, but the norms of state behavior that were articulated by the GGE, not as legal principles, but as norms that responsible states would say, yes, we don't think states should be doing these things, even if we can't point to why customary international law would stop them. We don't think they should do it. We don't think states, for example, should attack each other's critical infrastructure. Right. We don't think states should attack each other's mechanisms for responding to cyber emergencies. Those are areas where US, China, Russia, and others have agreed that there's a norm, whatever it means, that governs behavior. And I think that that's the area where we're going to see further development down the road. You've seen the Trump administration talk about its desire to work bilaterally with partners on cyber activity, which I presume would include further work on what we mean by some of the norms that the United States has already articulated. So that's where I would watch going forward.
So you think it will be bilateral in nature? You think it will be the Trump administration working with the UK or the Germans or whoever?
I think it's going to be partly bilateral. I think it's going to be partly, we'll see it in other fora. We already are to some extent. The G7 and the G20 ministers have come out with statements that address their concerns with cyber attacks on the financial sector, for example. G20, which of course includes some states who are adversaries in the cyber field sometimes. So I don't think it's just bilateral, but I don't see the move towards a multilateral treaty or a consensus UN process being the logical next step here.
Right. Ashley, what do you think?
Well, so
and I wonder if you could also talk about, since you're an academic, I wonder if you could talk about roles, a great academic, the role of the academy in this process. Are they contributing? I mean, with the Tallinn Manual, there was a fair degree of pushback from states. It's like, what are you guys doing? I mean, we're the ones that do norms in cyberspace, and we'll tell you what those norms are. So the role of academics like yourself.
So, well, let me start, I guess, with just
the
picking up
bigger
on the
question, yeah.
multilateral. It sounds as though the White House has said that it's hoping to continue to seek norm development with close allies.
Right.
So maybe that's the sort of one route. Of course, that's not going to persuade those who disagree with those norms. It might be helpful to actually really bear down with close allies on these very complicated questions, some of which we've raised today, to start to hammer out, even close allies can have disagreements about particular norms. So it's possible you could do some good work shaping sort of more consensus view among allies, but you're still left with those who didn't agree, for example, with the GGE. Those states are likely to disagree with what NATO or the Five Eyes comes up with. In terms of a bilateral precedent, as you know, the US and China entered into a bilateral MOU, a memorandum of understanding, basically to curtail economic espionage. So a very specific, particular issue that they were able to reach a sort of short agreement on. And I think the jury is still out about how effective that has been. There are some who say that economic espionage from China has slowed some. Unclear whether it's because of the MOU.
Right.
And China then entered into bilateral agreements with Canada and the UK, I think Australia. So I think that's another potential model, is to find discrete topics where there can be consensus among competitors, say,
Right.
and enter into some bilaterals on that. In terms of the role of the academy, I guess maybe I would broaden the question to say the role of non-governmental actors more generally. Right. I know there are a couple of fora being convened in Europe. The Hague example, I think, is not driven by states, but is a place where real experts are coming together to think hard about these things. And hopefully states will follow those activities and see the direction they're going. There's also, I think some people have done a kind of 1.5 track, or a sort of non-governmental track with people close to the government. And that may be another way to keep those conversations moving forward, even among states that tend to be pretty far apart on these issues.
So let me ask you a question we've not talked about in advance. So this is a trick question. Prepare yourselves.
Pass.
Pass. As I travel around and work with governments, it often strikes me that governments, it's difficult for states to agree on what the norms are that are applied in cyberspace. But it strikes me that it's often difficult for individual states to agree on what the norms are in cyberspace. It's because different entities of the government are not similarly situated. So in a country, if I talk to the folks in the Ministry of Defense, they give me one cut. And in the very same country, if I talk to someone at the Ministry of Foreign Affairs, they give me another cut. Typically, the diplomats want high normative firewalls. In other words, they want lots of international law and to be stringent to protect the country. And the operators want some degree of freedom to be able to operate inside systems in other countries and so forth. So to what extent you've both worked in government in exactly this area with other agencies. To what extent does that hobble a state's ability to come to internal consensus on what its position is with respect to a norm? Brian, we'll start with you.
I think it's very challenging for states to do those things, but unless you're going to be completely cynical about international law and the development of norms, I think it's essential for states to go through that exercise before articulating and endorsing a norm. So it may be that norms take longer to develop, which is one of the criticisms of what's going on in cyberspace, because it's hard to do those things. But I think it's essential that that's part of the process. It can't just be the foreign ministries and state departments of the world who are articulating norms. You must include the defense and intelligence and law enforcement parts of governments in this space as well.
But it's interesting. I've found that often there is collaboration between, for example, ministries of defense against their collective ministries of foreign affairs. So the various ministries of foreign affairs are talking to each other and saying we have to fashion a position. Meanwhile, over on the other side, the ministries of defense are meeting in a cafe on the route to whatever and coming up with their position. Have you experienced that? And I know, Ashley, you did Paul Mill affairs. So Have you experienced that to some extent?
Well, the U.S. government has a really robust interagency process, and probably a more robust, more coordinated one than many other countries. And not all of our power lies only with the Department of Defense. Apologies, I know your history, but not any one agency wins every fight.
Right.
And we have a National Security Council to help make sure all of the voices are heard. There are presumably other countries where the military is a much more powerful voice,
Sure.
and the Ministry of Foreign Affairs a much less powerful voice, human rights suppressed, and so on. So I think, there is a sort of irony. Our process is so stringent because we care so much about ultimately producing a norm that we could comply with, and not just saying, well, this seems like a nice norm, let's all agree to it. And our military is saying that's going to be a problem for us.
Right. Well, I'm getting this signal that we're coming to the end of our time. So all of this discussion has been about the prospects for the future. So in the few remaining moments, I'd like to give each of you an opportunity to talk about what's the prospect for, agreeing upon norms in cyberspace, identifying norms, resolving a lot of the gray areas that we've talked about. More of the same, or are you optimistic or pessimistic about the future? Maybe we'll start with you, Brian.
I'm a little worried. I'm a little bit worried about the Trump administration approach to international engagement in general, infecting what might happen in the international engagement space and cyberspace. I am encouraged, on the other hand, by statements that senior Trump administration's officials have made on their desire to continue working in this space. So I think we do need continued government will to do this. And I think this is an area that's worth watching, particularly from the U.S. perspective over the next couple of years.
Ashley, last word.
So I think and hope we were going to continue to stumble forward slowly on this. And I think one thing that might actually stimulate the crystallization of some of these more quickly is unfortunately a very serious attack where there's real consensus, maybe except for the state that did it. Maybe it's a non-state actor attack, but that really shows people the value of having clear norms that are complied by, at least in particular areas that are very, very sensitive. So it could be that that's what it takes to stimulate the crystallization in some areas.
Well, that's a horribly pessimistic note to end on, but I mean, international law has long developed in response to particular incidents, certainly in my field, international humanitarian law. Almost all of the treaties came after something horrendous occurred on the battlefield. So I hope that incident doesn't happen, and I hope we can move forward in some other direction. And with that, we'll turn it back to our hosts.
Well, thank you, Mike, and thanks to our speakers for a fascinating session. I'd also like to express my appreciation to the leadership and staff of the American Society of International Law. Our next live webcast will take place 1 week from today, on Wednesday, July 26th at 11:30 a.m. Eastern, 3:30 p.m. GMT, when we'll present an expert discussion on nuclear security and nonproliferation. You can register at acil.org/live. You will also want to mark your calendar for the succeeding webcast on the use of force under international law, which will take place perhaps appropriately on September 11th. If you would like to see this program again or missed any of the earlier programs in the series, they are all available on our website free of charge. And finally, if you've enjoyed this program, we invite you to become a member of the Society and to support our work with your tax-deductible donation at acil.org. Thank you for joining us. We'll see you next time.